everybody. The first presentation is by Miss Julie Elizabeth Boyd. She is a PhD student in the School of Law at Liverpool John Moores University in Liverpool, United Kingdom. And the topic and the title of her presentation this evening is called Considering Environmental Property Law Towards a More Eco-centric Position Within Legal Education. Good afternoon. In my presentation, I am going to talk about why current environmental laws are failing in their duty to protect the environment, and why, therefore, it is now necessary for a new discourse within legal education if we are to approach and address the challenges of increasing environmental threats and damage. We already know that human impact is causing environmental destruction on an ever-increasing scale, but laws which have been formulated to offer protection are not working. This is despite an increase in the development of environmental laws and legislation over decades and in many countries. And yet there is now an actual decrease in environmental protection. This is according to a United Nations report, which was the first global report entitled Environmental Rule of Law, published last year in January 2019. Environmental law and property law, both being interwoven, have been structured along an anthropocentric worldview. In other words, the human interest is placed firmly and centrally within this worldview. This has led to a detrimental impact upon the environment, animals and nature as a whole. Traditional environmental and property laws are rigid in their historical position as being strictly human-centred, designed to benefit human interest, often at the expense of all else. And it is now time to rethink this position. People have begun to realise that we have to put nature back at the centre of everything we do. Nature has just been pushed to the peripheries. We've exploited and dug up and cut down everything as if there was no tomorrow, as if it doesn't matter. This was a quote from Prince Charles given in a news interview on the 4th of June of this year. And as previously mentioned, despite all the environmental laws enacted to protect nature and ecological systems, there is still wholesale negative impact and destruction, leading to rapid species loss and irreparable damage. So nature must now be placed firmly into the centre of environmental law. Obviously, one of the best ways to evolve towards a more eco-centric governance system is to first examine and identify the legal doctrines and theories that obstruct such a move. These can be analysed by students of law while allowing wider debate and discussion around these themes. So placing the eco-centric approach in the centre of environmental legal education, and what does this actually mean? Well, there is a need for changes in environmental property law, teaching to embrace a more eco-centric approach. Now, such changes will undoubtedly present challenges to ways of thinking and doing things. However, such changes are essential if the current environmental crisis is to be addressed. New laws, or at least an overhaul of current laws, are needed to reflect those changes. The way forward, therefore, is to restructure and formulate a legal education in environmental property law which is eco-centric and less anthropocentric to achieve these very goals. So, when we go from the whole idea of anthropocentrism to ecocentrism, why is there a need for this change? Well, there seems to exist two schools of thought as to how and why we should regard and manage the environment. This was summarised by Andrew Dobson in Green Political Thought a few years ago. Humans ought to care for the environment because it is within our interest to do so. Therefore, it serves human benefit. Or, the other viewpoint was that the environment has an intrinsic value and worth of its own, and not just as a means to human ends, regardless of whether it could be made a means to human ends. It still has its own intrinsic value and worth. So, looking at the anthropocentric versus the ecocentric, we look at the current anthropocentric approach. And this means that the application of laws of property to land and the environment are based upon an anthropocentric worldview that human beings have a right enshrined in law, to dominate the environment at their will. Land, and therefore the environment, is a commodity defined by law. So it can be transferred, it can be bought and sold as a tangible object solely for the purpose of human interest and benefit, and there are very few exceptions to this rule. These laws legitimise and facilitate exploitive and destructive attitudes and actions towards the environment. So as a result, there is a rapid decline in the health of the environment and biodiversity, which we are seeing increasingly every day. However, the ecocentric approach reminds us that by continuing to maintain traditional views of property rights and how these ideas flow into the implementation of environmental laws will only hasten and deepen the negative impact upon the environment. So moving away from the idea of land as a commodity and an object of ownership will enable us to consider if land is being used in a beneficial and supportive way, and not just for the benefit solely of human beings and corporations and their interests. So there is now a need for learning and understanding a different approach to formulate future legislation which will enhance protection of the environment for all the inhabitants of it, from fauna to flora. So, how does this translate into adapting these kinds of ideas into the law curriculum, and why should it? Well, changes and adaptations to enable environmental laws in the future to succeed with an ecocentric position, it was suggested that they should be built upon three foundations. Number one, environmental laws would not continue to rely exclusively upon assumptions and models previously used. Rather, they would reflect the reality of how humans behave and how nature works. 2. Environmental laws would impose an affirmative duty upon humans. For example, people would not be told what they should not do, but rather they would be told what they should do by encouraging people to make positive decisions and choices. And number 3, instead of relying on rules that seek to prevent humans from creating negative environmental externalities, they would create incentives for humans to create positive ecocentric externalities. So when we think about making the changes, we look at how we can do this. And the first step, obviously, is to start moving away from this very old anthropocentric approach towards a more ecocentric knowledge and understanding. So initiating these new approaches into the study of environmental and property law equips the law student, especially those wishing to become environmental lawyers, with the knowledge and skills that will help them better understand, interpret and address environmental challenges, and to serve those communities and causes they will represent. So we see these steps in this diagram here. So then moving on to step 3, we will educate a new generation of future lawyers with new understanding and approaches. This may help them better to influence and implement future law reform and develop and establish new governance systems. Leading on from step 4 to step 5, we look at the laws which can be drafted to better benefit our environment and all who inhabit it, including humans. So that's benefit to the environment, animals and people in the future. So turning the tide. The traditional teaching of environmental property law requires a fundamental reconceptualisation, and students need to be prepared for growing environmental challenges. These environmental challenges will require more eco-centric based learning and approaches which protect and benefit all beings, and where nature needs to be at the centre. So all laws are based upon knowledge and understanding of societal systems. Any new knowledge is needed to understand how we are to address issues such as climate change, ecological degradation and species loss. And by moving away from current established anthropocentric approaches, understanding and world views of the environment as learned from traditional environmental law, which is enshrined in legal systems, and going towards moving to a more eco-centric knowledge and understanding. Such changes obviously may take time, as any effective legal reform would only be brought about by all these changes in society already being seen with climate change and consumer practices, and also educational initiatives. Examples of these are with the forest schools for children and young people. Any transition towards developing a more eco-centric environmental property law is not without its challenges, given the hugely complex subject area. But education would serve as a springboard along with re-establishing human connection with our environment. Because the young people who learnt about their environment at forest schools may want to become the environmental lawyers of the future. What they have learned at the practical level may be valuable tools to prepare them for academic education and to open up new discourse and responses to how we can address the failings of environmental laws by viewing it through a different lens. So the summary of all this is basically that by applying the laws of property to land and the environment is a result of the anthropocentric worldview, which shows that human beings have the right, this is a right enshrined in law, to basically dominate the environment at their will. And land, and therefore the environment, is a commodity defined by law, and those same laws legitimise and facilitate exploitive and destructive attitudes and actions towards our environment. It is this very legal perception of how the environment can be treated which has resulted in the emerging ecological crisis. Therefore, there is a need to consider and recognise responsibly for the environment, instead of relying upon the assertion of rights as laid down in law. This in turn would also lead to strengthen the rights of Indigenous people, whose lands are being destroyed or controlled by external agencies who are involved with destructive practices such as tree culling and introducing genetically modified organisms, GMOs, into the soil. So by directing ourselves from the idea of land as a commodity and an object of ownership would enable us to consider if land is being used in a manner which is not just for the benefit solely of human beings and corporations and their interests, but for all the inhabitants of it, including humans and animals. Because it is certain that to continue to maintain and ingrain the traditional views of property rights and how these flow into the implementation of environmental laws will only hasten and deepen the negative impact upon the environment. There is a need for a new way of looking at and approaching these standards, and restructure and implementation of workable alternatives which can be fed into how we formulate legislation is the way forward for the future if we are to tackle climate change and the ongoing and increasing ecological crisis. And in conclusion, there is a quote here from Mary Arden, which says, "Law is a lasting social institution, but it must also be open to change, respond to the changing needs of society, arising from changing social values, constitutional shifts, or the need for a better legal framework in a particular field." And I think we have now arrived at this time in our society where we do need to rethink about our environmental laws and how they need to be changed by careful consideration. Thank you. If any participants have any questions, could you please send them via the chat box? Thank you. There's a question here from Simon Bruman, and his question is, do you think lawyers and legal professionals are ready for this change? Well, the answer is probably not. There are some lawyers and legal professionals out there who are quite open to change. They're already looking at issues surrounding animal law, which can be tied in with environmental law as well. So I think in the future, I don't think it's quite open yet. I think there will be challenges, as I've already stated in the presentation. But obviously, it comes from education and it comes from the younger people and the changes in our society at the moment, and also the way the environment has been impacted. I think sooner in the future, we're going to have to look at being ready for changes and educating people, and certainly students, law students, to become the lawyers and legal professionals of the future, to be able to adapt to these changes. Thank you. I've got another question here from Michael Lower. Does this connect with organisations that promote land ownership for community benefit? And does this point the way forward, facilitating the purchase of land for community environment benefit? Well, to be honest, I'm not quite sure about that particular point, Professor Lower. I've not actually delved into that part of it yet. So if you just forgive me for not being able to answer that at this moment in time. There is some issues about organisations purchasing land for community and environmental benefit, but I think that'll have to be looked at in greater detail on a case base. Each base is different. So we'd have to look at exactly what they're purchasing it for, what the benefits are for. Are they for the people, or are they for the benefit of the land? Because is it going to be more towards an ecocentric benefit? So I can't actually fully answer that question at the moment, but I will move on to another question from Grace, who's asking, other than the legal regime on land law, whether the criminal law or other legal systems require to be changed for eco-centric purpose. Again, that is another issue which could well thread into all of this, but obviously would have to be looked at. Whether some issues around, for example, pollution of the land and rivers, whether they tie into criminal law. I'm sure some of them do, but criminal law actually isn't my area of study at the moment, although I do think that would flow into it at some point. But this is a huge challenge, as I've already stated. It's a huge complex area, and as we know, law does bring into a lot of different areas: criminal, tort, land law, property, environment, animal law. So it is a huge area, and it's not going to happen overnight, and it has challenges. So hopefully it's all basically starting from foundations and working through everything. And I mean, there has been some developments in New Zealand about granting legal rights to some rivers and mountains. And that's more to do with also bringing in the Maoris, because for a long time the Maoris were under British colonialism, and a lot of their land was taken from them. So what's happening now is, in New Zealand since 2017, the Parliament there has recognised the river, I think it's a Wangani River, the world's first body of water to be granted legal guardianship from the Maoris. And also there's some mountains as well. So there are some jurisdictions which are moving on to looking at this, and also to protect Indigenous peoples and giving more rights over their own lands and how they protect them and how they manage them. So as I said previously, it is a huge challenge. And I think in certain areas, for example, in New Zealand, what they've done is they brought in a lot of the Indigenous attitudes towards the land and the environment, and they've written that into their constitutions. But again, this whole thing towards a new eco-centric focused orientation is more to do with responsibilities rather than focusing exclusively on legal rights. Of course, obviously, once they're embedded in legal systems, then we can better enforce those rights.